At 10:05, ask everyone to please rise, and new Commissioner Leonard will lead us in the pledges of allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, to Texas, one state under God, one and indivisible.
You may be seated. I believe we have all commissioners in attendance today, and I would just remind the audience again, if you wish to speak on any item, there are documents you need to fill out and hand in so that we know that. And remind you that each speaker will be given 3 minutes to make their case. So if you're intending to speak, be prepared for 3 minutes. And now, we'd like to welcome the two new commissioners that have been graciously agreed to serve the people of Texas in this role. Bob Leonard from San Antonio. Let's hear for Bob. And I'll do my best to say Raita Stevens from Pearland, Texas. And of course, we want to recognize the people who served the people of Texas for about 6 years in this role, and we have one of those former commissioners in our midst. But before I recognize her, I would say Jamie Hensley was unable to be here, Jamie from Lufkin, and we appreciate her. And we have a little thing or two we will send to her. And Commissioner Justice from Arlington, you want to come forward? We thank you for your time. We appreciate you as a broker, and I'll even let you talk now if you'll come on up here.
Now, see, you're going to make me cry, and I didn't want to cry, but it's already his fault. She came over and hugged me.
It's on the agenda.
You know, it's always funny when you get to do something like this, and then it's kind of all over. And so I came in today because I wanted to say thank you. And the thank yous go out to the people who really make this happen. This staff here and here, they are absolutely amazing. They anticipate everything before you even need it. They get it together, they explain it, they answer questions, and don't make you feel like a fool about a new subject that you don't know anything about. In the time, first of all, this is not a position I ever asked for. It kind of found me, and it was a really unique one for all the years I've been in real estate. But during the time I was with the commission, we hired a new director. Forgive me, I know the titles are all different, but that's best I could get. We moved locations. We made a change in agency status. We constantly worked to improve classes and education requirements so that agents are more knowledgeable and the public is better served. We worked to improve transparency to the public of responsible parties they work with on transactions. And my personal favorite, because I found it out the day I walked in that I couldn't teach anymore for the next 6 years of my life, my personal favorite is that some of the smartest people in the room now get to share their knowledge with the public. And I think that's an absolutely wonderful thing. So thank you to all of you for the opportunity and the friendships, and I'll be watching to see what you're doing. Thank you.
Well, Joanne, you're the first person I made cry today. Just thought I'd say that. Yeah. And as Commissioner Jones says, it won't be the last.
Amen.
So the first item on our agenda item number 4, is the election of officers. And we have 2 officers that we elect at this meeting, the vice chairman and the secretary. I guess I will recognize Commissioner Turner, who has a motion in this regard.
Madam Chair, I nominate Bill Jones to continue to serve as vice chair
I have a motion. Do I have a second?
Second.
Second.
I have a second from several places. Is there anyone else? All in favor say aye.
Aye.
Opposed, no. Motion carries. And now for secretary.
Madam Chair, may I recommend Mr. T.J. Turner as Secretary of the Texas Real Estate Commission for this purpose?
I have a motion. Do I have a second? I also have a couple of seconds. Is there anyone else? Seeing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. Congratulations, Commissioner Jones and Turner, particularly Commissioner Turner, who's taking over the role that Commissioner Justice played, and I believe that you get to watch through the entire video and make sure that none of us are doing anything untoward. Just kidding. Not. So the Budget Committee, this is a time, agenda item 5, when we make committee appointments, and I have 3 people who have expressed a willingness to serve on the Budget Committee, and that would be Commissioner Martinez, Commissioner Westcott, and Commissioner Alley. And if they have changed their mind, it would be the time to say that. So no, it's all good. And for the Enforcement Committee, who have some duties to take some action when we're prior to being at full commission, and that would be Commissioner Turner, Commissioner Stevens, and Commissioner Arriaga, if that's acceptable. Yes, okay. The Inspector Committee, we do not have a member to bring forward, not as a committee member, we do not have a member to bring forward, but as the committee liaison, Commissioner Jones has agreed to continue to serve in that capacity, and Commissioner Leonard has agreed to take over the job as the liaison to the Education Standards Advisory Committee. And also reappointed to the Education Standards Advisory Committee would be Ronnie Willis of Corsicana, Bill Bradshaw of Austin, Pat Strong of somewhere in the San Antonio area, I've lost my mind, Andy Hemmings from Beaumont, Bill Evans from Austin, and Rita Klein from Houston. So those would be the appointments that we would make today. And now would seek to have agenda item 6, staff and committee reports, and I guess we start with you, Mr. Olmixon.
Good morning, commissioners and guests. Commissioners, welcome to your regular quarterly meeting of the commission. Thank you, as always, for your service to the people of Texas as volunteer policymakers. It's because of you that Texas continues to lead the nation in efficient and effective regulation of real estate-related professionals. Recall that this meeting is being live streamed over the internet. Although currently it does not have video content, the screens are being shown and your voices are being recorded. And if we restore the video portion, we will let you know. And then former Commissioner Justice can watch you all in the future in all of your meetings, as she said she was going to. Although this is so please be aware, we're also video recording. We have a backup video recording always going, because that is the official record of your deliberations and actions. So please be aware and ensure that your microphones are on when speaking. And although this is a regular quarterly meeting, there are also several firsts here today. Of course, welcome to our 2 new commissioners. We look forward to your contributions to the continued success of our mission. The staff wishes to express our sincere thanks to Commissioners Justice and Hensley for their years of service. You made us better by your leadership. And this is the first meeting at which participants and attendees may receive CE credit for their presence and interest. We thank those who made time to be here. And today you will also hear a summary review on 2 topic areas that we are responsible for, but do not consider regularly in our monthly reports to you. And that's residential service companies and timeshare, registered of timeshare projects. This is an annual report that we will be providing. So in addition to our regular business of hearing, your regular business of hearing contested cases, considering claims on the recovery fund, considering the proposal and adoption of administrative rules and approval of forms, there are also important operating policy topics to be considered today. You annually approve our agency's investment policy to ensure the protection of public funds entrusted to your stewardship. And most importantly for year 2016 is to approve the topics and schedule for our biennial strategic planning project. Every even-numbered year, we are charged with updating our 5-year strategic plan, and we have a discussion and action item for your consideration later in the meeting. Your staff has been incredibly busy since your last meeting in November. We have implemented all of the January 1 and February 1 rule and policy update driven by laws and rules. We've been out speaking to groups of license holders in Kerrville and San Marcos, to the National Association of Real Property Managers group here in Texas, and we spoke twice to different audiences at the Texas Association of Realtors winter meeting just this past weekend. Current issues regarding the posting and delivery of required consumer protection notices and the updated information about brokerage services disclosure form are the areas of most intense interest. I'm happy to answer any questions that you may have. Otherwise, I will turn it over to each of the division directors to give their operational report highlights.
Any questions for Mr. Olmixon? Thank you, Mr. Olmixon. We call forward Ms. DeAnda.
Good morning, Lori DeAnda, Director of Reception and Communication Services. Before I refer you to the RCS reports, I am introducing 2 new team members. First is Matthew Powers. Mr. Powers began his employment with TREC on November 9th and is originally from San Antonio. He was previously employed by the State Preservation Board as the Group Sales Coordinator at the Bob Bullock Texas State History Museum. He studied aviation science at Utah Valley State University and is licensed with the Texas Department of Insurance. Mr. Powers served in the U.S. Marine Corps and was stationed at Fort Sam Houston. He is extremely excited to work for the agency.
Is he here? There you go.
Let's stand up.
Go ahead and stand up.
Next is Lamont Barlow, who began his employment with TREC November 16th after being employed with the Texas Department of Insurance. He also worked for other state agencies, which are the Teachers Retirement System and the Texas Comptroller of Public Accounts. He looks forward to applying his solid work ethic within the agency and is also extremely excited to work for the agency.
Awesome.
Now please refer to the C1 report. In December 2015, we received a total of 17,914 calls. We assisted 201 walk-ins and responded to 6,816 emails. The next report is the C2 report, which is a report in regards to the customer service surveys that are submitted by the license holders and the public. In the month of December, we received a total of 21 surveys, which 9 of them were responded by email, 3 were handled by phone, and 9 were submitted anonymously. And of the 21 surveys, 7 were positive comments in regards to the assistance of staff. The next report is the C3 report, which is a new report that will be included in all future meetings. This report involves the average hold time and the average length of time it takes to complete the call. These numbers are listed per quarter. For the months of September through November 2015, the average hold time was 8 minutes and 30 seconds, and the average length of the call was a little over 7 minutes. And this concludes my report. Does anyone have any questions? Yes, sir.
Outstanding that we have, over the course that I've been here, that we have improved so significantly in terms of response. Do you have a goal? I mean, I'm looking at, what, 7 minutes? That's great. I mean, it's great. Do you have a goal to get it down to a certain number?
Well, our goal is to not have a lengthy hold time. And our main mission is to try to offer exceptional customer service. So what we do is when we receive the call, We make sure that we listen and we provide all of the information that is necessary that will prevent the caller from having to call back. So it may take a little bit to conclude the call, but we're doing the very best to make sure that all questions are answered.
Commissioner Alley, just so you know, we do measure, we have a measure, and that is, we measure against this standard, which is our objective is that our average call hold time never be over 10 minutes. Okay, so we measure ourselves against that. And if we continue to beat that over time, we will lower that standard.
Do you inform the caller about the estimated hold time?
Yes.
Is there a way
We-
that you
th-
can
there's
say that
a-
the call is going to be?
Yes, sir. The greeting message will give them an estimation of what the hold time is. Any other questions?
Any other questions? Thank you, Ms.
Okay,
Worthing.
thank you.
Ms. Tienda. Ms. Jackson? Education and licensing.
Yes. Good morning. Gwen Jackson, Director of Education and Licensing Services. If you would direct your attention to the L1 report, this is the report that provides the December fiscal year comparisons for the number of broker and sales agent applications received, licenses issued, and renewal activity. As of December, we had received 7,806 original applications, which is a 16.8% increase over that of December 2014. And there was an 11.4% increase in total licenses issued from those applications. 353 reinstatement applications were also received during this period, which was a 13% decrease from that of December 2014. Recall that reinstatement applications are those filed by sales agents or brokers who want to come back into the business after their license has been expired more than 6 months, but less than 2 years. The decrease in receiving this type of application is probably because our license holders are renewing timely so that they can remain in the business and continue to work. During this period, 83.5%, or 19,755 of the broker and sales agents who were eligible to renew did so. Are there any questions on this report? The next report is the L1A report. This report provides the fiscal year comparison for applications and renewal activity for the inspector program. While this is a report that we've traditionally provided to the Real Estate Inspector Committee, we plan to begin to present this report to the commissioners as well in the future. The inspector population is much smaller than that of real estate, and their totals will be much lower, and the percentages may have a wider variance. 288 original applications were received, reflecting a 56.5% increase over December 2014, and almost a 34% increase in licenses issued. During this period, 67.7%, or 183 of the inspectors who were eligible to renew did so. Are there any questions on this report? Please refer to the L2 report. This report provides a breakdown of our active and inactive license holders, as well as our total number of license holders and registrants. As of December, there were 44,541 brokers, which is slightly lower than the 44,581 that we had in December of 2014. While we've seen only slight fluctuations in our broker totals, there has been a steady increase in the number of sales agents. The total number of sales agents in December 2014 was 108,782, and our total this past December was 117,453, which is about an 8% increase. Our overall total for both brokers and sales agents is 161,994, or a 5% increase over December 2014's total of 153,363. There's a slight increase in the number of inspectors and ERW registrants, which brings our overall total for license holders and registrants to 167,559, or a 5.5% increase over that of December 2014. Are there any questions on this report? The next report is our year-to-date comparison of examination activity as of December. And in reference to this report, our first attempt pass rate for sales agents was 46.3%, and our first attempt pass rate for brokers was 48.5%. This was compared to our 2014 percentages of 50.4% for the sales agents and 48.1% for the brokers. On the bottom of that comparison sheet are our inspector comparisons. First attempt pass rate for the real estate inspector was 14.3% compared to 50% in 2014, and for professional inspectors was almost 47% in 2015 and 60.1% in 2014.
Ms. Jackson, do you attribute those significant, and we both sat through this meeting, those significant changes to any changes that we could have made to precipitate that?
In reference to all percentages?
The
or
real estate inspectors.
For the real estate inspectors?
50 down to 14.
Yes. For the real estate inspectors, we're currently looking at the pass rates for both the national as well as the state portions. In addition to that, we'll be looking at the content areas in which individuals appear to be having the lowest pass rates.
Thank you.
Any other questions on this report? The next report is the L4 report, and this report provides the number of approved instructors who are eligible to teach our approved courses. There are a total of 2,876 CE or continuing education elective instructors, 1,359 instructors who teach both qualifying and CE electives, 497 who were certified to teach the legal update and ethics courses, and 267 who were approved to teach the broker responsibility course. The second half of the chart provides totals for the inspector instructors. There were 31 approved to teach only inspector continuing education courses, 89 who teach both qualifying and inspector continuing education electives, 41 who teach the Texas Standards of Practice, Legal and Ethics Update courses, and 40 who teach the Inspector Ride-Along courses. Are there any questions on this report? If there are no further questions, that
Thank you, Ms.
concludes my
Jackson.
report.
Mr. Moore, Standards and Enforcement.
Mark Moore, Director of Standards and Enforcement Services. We got 5 reports today, the typical 3, which are the case status report, the case aging report, and the subject categories report. And as Mr. Oldmixon mentioned, we're going to have 2 reports on the timeshare registration program and the residential service company program, which Ms. Ravenberg, the manager for those 2 programs, will present. On the case status report, which is on the screen now, we had a good quarter. We closed a few more cases than we opened, which is always nice in the short term, obviously impossible in the long term. The number of cases coming in has slowed down a bit. It had been about 200 a month, and as you can see, the last 3 months have all been in the 150, so that allowed us to catch up a bit on some of the cases. Moving on to the next report, this is our case aging report, and as you can see, 96% of the cases are less than a year, and only 2 cases right now are over 2 years old. The next report is the complaint subject categories report, and as you may remember, this is basically the complaint subject categories, just sort of the general gist of what the case is about. It's not necessarily what the complainant alleged, because they may not be able to spot everything, and it's not necessarily what was proved on violation, because many cases do not have violations where we don't find them, but it sort of summarizes the kind of main areas that we're seeing. And you can go to the detail page after that. And this just gives the detail by month, sort of the hard data. And you can see there's significant variation from month to month, but over a while we get percentages that tell us some idea of what's going on our complaints. Do y'all have any questions on these three reports?
Yes,
Mr.
I have a
Moore,
question.
I'm sorry. Go ahead, Commissioner Alley.
I'm always intrigued about the pie chart and seeing where the complaints are. And one of my concerns, I know continuously we have the leasing and the property management as an area that seems to still garner a significant amount of complaints. And I know you say sometimes the complaints don't necessarily come back to actual types of problems that we have. Is it anything that you can see that might be able to help us in that area?
Well, we hope that discipline helps some on that. Those actually, it is a problem area. It's not just that we get a lot of complaints on. And they're actually pretty difficult cases, too, because there's a lot of parties involved in these and lots of month and lots of checks. So there's the investigation's a lot harder on those. But we have done a lot of pretty significant discipline in that area. And we're pretty confident that if someone is a repeat violator, that we do eventually catch them. We are complaint driven, so obviously the tenant or the owner, and they're about 50-50 on those that complain. Usually it's the owner that is more important in some ways because that's who the license holder owes a fiduciary duty to.
Mr. Moore, I was going to ask you, we have obviously a large number of visitors today who might be wondering about the aging report, and I was just going to, first of all, congratulate you because when I began my stint here, the aging report was much more aged than this, and things lasted a lot longer. And I believe that the cases that are the oldest, if you will, and you might kind of tell that those are generally, no offense or anything, where attorneys are involved and various things are filed, which cause this to go on and on and on. Is that
Yeah, that's correct.
a layman's term? Yeah.
Yeah, those are typically ones that have been referred to the State Office of Administrative Hearings, which is the administrative body that they sort of roughly form a judicial role, but they basically serve as a fact finder and make a proposal for decision for this commission. And those actually take a while because it takes months and months to set it, and then there's usually continuances, and then they get a new lawyer and so on. So those can add, so those older cases are almost always cases involved in that process.
I really wanted the audience to understand that you guys are doing the best job you know how under the circumstances that you're dealt.
Thank you. We appreciate that.
Appreciate that. Are there any other questions? Yes.
There is. Mr. Moore, I echo the sentiments because obviously enforcement and proper enforcement is important to all of us, and thank you and the staff for what you have been doing. One of the questions that was raised earlier brings me to the question of, can we start, I'd like to see if we can start calculating the ones that don't result in any type of action. Again, somebody that had a complaint and again felt that there was certainly something onerous that took place, but if it's doesn't materialize into something, that would be something good for us to see, because that might also help us generate what needs to be corrected or called out a little more specifically, whether we're talking about the leasing property or we're talking about a different agency. So it's kind of the echo, if you will. So I appreciate that.
Oh, you're welcome. Yeah.
Well, and we certainly use the information that is provided in your complaint subject categories to look at what we will focus on in the required classes, so the audience knows. I know you know that.
Okay.
Thank you.
Thank you. And now Ms. Ravenberg will talk on the next two reports, which are the timeshare registration and the residential service company. Thank you.
Thank you, Mr. Moore. Ms. Ravenberg.
Good morning, Commission members and Madam Chair. I'm here to talk today about the timeshare and residential service company programs. First, a couple overview items. Both of these statutes deal with consumer protection issues, as does the Real Estate License Act. There were no substantive changes by the 2015 legislature, so we have nothing new, unlike some of the other laws. The staff involved in this program include 2 attorneys, I am one of those, a legal assistant, and an administrative assistant. In addition to working on these 2 programs, we also all have our own broker and sales complaints, so we many times wear multiple hats. Like everything else at the Commission, Standards and Enforcement Services, where we have paperless system, we've also gone paperless with the timeshare and RSC, and it's cut down. We don't have the bunches of files we used to have. Looking on page 26, there's a written summary there talking about timeshare. 25. Sorry, it is 25. Timeshare registration is like a permit to sell, is how I describe it. A developer, in order to sell to a consumer, has to have their timeshare plan registered by the commission. The consumer protections, the two main ones in the statute, are an automatic 5-day cancellation. There aren't very many laws that have that. There is also a required disclosure statement. It can be a rather lengthy document. The Timeshare Act also dictates certain language that has to be in the contract, as well as the wide range of categories of information in the disclosure statement. The staff, we review applications for new registrations, amendments, and renewals to confirm compliance with all of the statutory requirements. The Commission, by rule in the application form, has laid out a lengthy number of requirements, and we want to make sure all of those are in place to confirm that consumers will be protected. Everything from the money has to go into escrow and those kinds of things. The Commission, from the point we started registering timeshares in 1985, has registered 401 plans. We currently have 126 active plans. We don't get very many complaints. As you can see, in 2015 we had 34. They mostly fall into two categories. One, consumers who are upset with what happened at their sales presentation, what they were told didn't pan out, and those kinds of things. The other complaint we've been seeing quite a bit of is on resale companies. In many cases, they have, it's the too good to be true, we've got a buyer for your timeshare, we know you've owned it for 10 years. Oh, by the way, give us some money up front. So many of those are scams, and people call us to find out if that company's registered, and we had a lengthy discussion the other day. There's a lot of questions and a lot of things to work through, but so many of them are Mexican and they're not deeded. So of course on a resale we never get to timeshare licensing issues. And the focus of the Texas Timeshare Act is on original developers with the original sales to consumers. It doesn't really go to the resales. So a lot of times I can tell by looking at the Google of that address, it's an empty lot. I can look on the Secretary of State records and tell people there's no company like that in San Antonio, and they have to take away from that maybe they don't want to do business, but I think that's a good consumer protection issue. Although it may not be within our jurisdiction, we can help people understand whether registration is required for, or any kind of regulation by the Commission is in place. Before I go to residential service companies, was there any questions about timeshare?
Commissioner.
Madam Chair, Counselor, I see we got 4 people on that department, I guess, in charge of timeshares, 2 attorneys, legal assistant, and administrative assistant. We have 34 calls, and last year was 39. How much of your time is answering questions or complaints?
This is frankly a small part of what we normally do. If it's a couple hours a week total. The other calls we do get are people wanting to register, and we have to walk them through those applications. Essentially, Standards and Enforcement Services does everything for this program and the RSC program, does the applications, does the questions, just because it's so specialized and there's so few of them. So it's not that much in the big picture in terms of what everything that SES does.
But your staff stays pretty busy, even if it's only at 30 complaints a year.
That's correct.
Thank you.
Okay, moving ahead to residential service companies. That's page 26. The summary is there. We use the acronym RSC, and that, of course, the C stands for contract. Many times these are referred to as home warranties also, although they're not warranties and they're not insurance. They're simply residential service contracts where a consumer pays a fee to a company who says they will, you pay us the money, we will fix and repair things as listed in our contract. Under the Residential Service Company Act, the company has to have a license to be able to sell to Texas residents. The consumer protections in this area include requirement that the residential service company has to initiate service within 48 hours. That maybe was a big deal in 1979 when the first regulation, picture having to make phone calls. Everything now is an automatic dispatch. There's emails, there's everything. We don't see any violations in that area. The bigger things we look at now are whether a company has a funded reserve. That's basically a pot of money set aside. It's 50% of the unearned contract revenue that has to be set aside in what I call safe investments, governmental things. So there'll be money to pay claims as the company claims are filed and things need to be repaired. As of January 1st of 2016, there were 38 licensed companies. There was only 17 when I first started in 2003 doing this program, so it's quite an increase. The residential service contracts can cover structural components, appliances, electrical, plumbing, heating, cooling, air conditioning systems in residential properties. We get a lot of questions, and this is one place we do get questions, whether whatever it is they want to offer fits within our box. We have to sit and study it, and invariably you got to look at the paperwork to figure it out. Some companies now also only cover one part of a system, like a water line or something. They're not the whole home, as we have traditionally seen. Marketing takes a number of different forms, including traditional marketing representatives with real estate agents, but there's a lot of them being sold over the internet. Some years ago, some of the companies that did a lot of internet selling didn't understand they needed a license here. We jumped on them, made them aware of our requirements, and they either got in compliance or quit. So I think the regulation works, and the Act also requires us to do examinations of each company. It's like kind of like an audit. We look at a company's financials and their funded reserves to make sure that money is sitting there, as well as other aspects, including contracts, complaints, the call center, contractor issues, lawsuits, basically pretty much everything to do with the company. The companies also have to report to the Commission twice a year in their annual report and their mid-year reports. They report on their funded reserves, their financials, what their contract fees they've collected, those kinds of things. From the information in mid-annual and mid-year reports, the Commission compiles the activity report. It's pretty much a summary of all the different companies. We have the numbers finished for 2014 is the most recent, and they show that in Texas there was over 1 million contracts issued in 2014 and 182 million in claims paid. So that's a lot of consumers that are being helped by the companies in terms of you pay your money, you get your claims taken care of. Again, like timeshare, haven't been very many complaints, and last year is pretty typical what we see. This probably keeps the number down, is that this program has an ombudsman. We have a phone number that's in every contract, in addition to information in every single contract, which by rule says this company is licensed by the Commission, complaints can be filed with the Commission, and our ombudsman, Cindy Mahoney, who's the legal assistant with our program, she will take calls from consumers. She sometimes has to help them understand the contract. She also has good liaison with the companies, and we can many times get things worked out and things will get fixed, or consumers will go away knowing someone's listened to them, even if, maybe their dishwasher won't get fixed. That's all I had. If any questions about residential service company?
Mr. Westcott?
I was just going to ask, and this may be a dumb question, but as Commissioner Justice said, dumb questions are always responded to well by the staff. So both of these programs are eligible when there are complaints for the consumers can recover against the recovery funds. Is that correct?
No, they aren't.
Okay.
There's not a recovery fund for either of these.
Thank you.
Any other
Madam Chair,
questions?
I do.
Turner?
Do you have any idea, and sorry to put you on the spot, but out of these complaints that were received in 2014 and 2015, what percentage of those complaints resulted in any discipline?
Of those complaints, of the consumer complaints, none that I know of. There was, I'm not sure it was which year. Sometimes there are technical problems. People don't have funded reserves, but the consumer complaints can generally, we get something worked out. The companies are very willing to work with us and sometimes need to be convinced a little, but in general, they pretty much work with us, so I don't believe there's any of those that were consumer complaints. And traditionally, there've been 2, maybe, ever, that the companies, that were substantive complaints, and one of those was from 2003.
Okay. Do you have any, are there any controls or anything in place, or do you even have for, if there are repeat offenders, if you have a company who receives more than one complaint or several complaints, or is that even a trend that you've noticed?
You know, there's so few. There's sometimes they have, they had 10 now, they have 15 next year. And when you look at that many out of, 80,000 contracts or something, there just aren't that many. There are, and we would apply the same criteria that Standards and Enforcement Services uses for real estate agents. Some of those multiple offenses, the gravity of the offense. We would use that same analysis if we had a repeat offender. Of what are we going to do with them now?
Okay. And so, sorry to belabor this, but as I understood your answer earlier, the 102 complaints in 14 and 87 in 15, all those were able to be resolved without any disciplinary action taken against the companies?
Yeah, some of those are consumer complaints. Some of those may have been related to technical things. I don't have a breakdown of that, but again, the technical would either be some administrative penalty for a technical problem, or they got an advisory letter. And in order to track those, we have to open a file. We have no place to put the infraction, the paperwork, so to speak.
Okay, thanks.
Quick question. Is this on? The Ombudsman program, is that responsible for the reduction in the number of complaints that we receive?
I think so.
And are those calls that go to the Ombudsman included in these complaint numbers?
No, the complaint numbers are only the written complaints. Some of those may end up, some of the phone calls, you can't satisfy them, they'll file the complaint anyway. But the Ombudsman, those are not included in the complaints.
How long have we had the Ombudsman program?
From the 90s,
Okay.
at least.
And is this reduction in the number of complaints a trend?
No, it's always right around 100, give or take.
Any other questions? Thank you, Ms. Ravenberg. Mr. Spiropoulos? Something.
Good morning. Before I get into the I-1 report, I'd like to talk about the results of the DIR penetration test. So DIR is the Department of Information Resources. They're responsible for sort of overseeing IT in Texas, helping the agencies get access to certain services, and they help us with testing as well. So they test our network and they test our website. And every year we go through this, what's called a penetration test, to see if they can get into our network and access our systems. They had 2 objectives during the test. The one objective was met, so they were able to gain access. We immediately remedied the problem and rectified it so that it doesn't, give us exposure again on that particular item. And so now we are no longer able to be accessed in that same way. The test took place between December and January, and one of the tests that they performed actually took our website down for about 36 hours or so. And so the unfortunate result of that is that we have a little bit of data that's missing in this I-1 report, so I just wanted to let you know that's the cause for that.
Okay.
So in the I-1 report, if we look at the website pages viewed and total monthly unique visitors, the fiscal year-to-date totals are, we have increases on both sides. We also have increases in online applications, online renewals, and sponsorship transactions for the fiscal year-to-date totals. From 77% to 79% for applications. We went from 94 to 96.7 on the renewals, and 88.6 to 91.1 on the sponsorship transactions for online utilization. Any questions on the I-1 report? Okay, the I-2 report is tracking our online utilization for applications, renewals, and the online management tool over a trend of a year. So we continue to trend up in all three categories, for all of these three metrics. And we're now above, I would say, so we're above 90% on applications, or just around 90%. We're above 95%, of course, on renewals. And then for the relationship management tool, we're hovering around 85 or 89%, somewhere around 90 as well. So we continuously see a positive trend in terms of online utilization for our website and our tools. Any questions on the I2 report? Thank you.
Thank you. Ms. Huerta?
We go from the tallest director to the shortest. All right. Good morning, Commission members. Melissa Huerta, Director of Staff and Support Services. And before I start, I want to introduce a new staff member to our division. Sunita Woolen is our new HR specialist. Sunita started on January 2nd. Sunita is from Huntsville, Alabama. She received a Bachelor and Master's of Science degrees from Southern Illinois University in Carbondale, Illinois. Ms. Woolen has an impressive background in computer technology and in the education arena in various capacities. She spent several years of her career at Alabama A&M University in Huntsville, Alabama, and the Citadel, the Military College of South Carolina. Her future goals include obtaining a PhD and growth within the human resource arena. We are pleased to have Sunita on our team. All right, so the first report before you for me is the S1 report, and this is the budget status as of December 31st, 2015. And I made some comments in the comments field. They're really tiny, so it's a little hard to read, but they're explaining the variances. A couple of ones that I wanted to point out are the office rent expense. So the lease with the Facilities Commission has been paid in full for the year, and this is due to the SWICAP allocation. And for new commission members, the SWICAP is a statewide cost allocation plan, and expenses for services that are provided by a central agency, such as the Comptroller's Office or the SAO, the State Auditor's Office, such as accounting, payroll, building maintenance. These are identified by the Governor's Office and then allocated to the appropriate agencies, and then the agency has to reimburse the General Revenue Fund for these expenses. So our lease is written so that our lease payment is reduced by the SWICAP expenses related to the building. Our maintenance and repair, we've already paid the Versa annual maintenance for the year, so that's why that expense is already shown as pretty much expended. Are there any other questions on this report? No? All right. Oh, I also wanted to explain the revenues. So the license fee collections on the report towards the bottom are above projections due, and that's due to the increase in collections of sales and broker applications and renewal fees. And as reported by Gwen in her L1 report, applications received are up almost 17%, and our renewals are up about 11% from the same time last year. So that's why we have an increase in our revenues.
Thank you.
Okay. All right, the next report is the S1A report. And these are the investments of the reserve balance in our operating account. We currently have 5 Treasury notes that will mature at various times. The market value of these investments as of December 31st is $4.9 million. The interest earned from September through December is $7,187.50. Are there any questions on this report? All right. The next report is the S2 report. The S2 shows the status of the real estate recovery fund as of December 31st. So the total investment market value is almost $1.3 million. The available cash balance of $814,199.45. So the combined balance of the investments in cash is $2.1 million. The reserve has a potential payments within 90 days of $798,305. Are there any questions on this report? All right. My next report is the S3 report. This report shows that we have paid 7 claims so far this fiscal year in the amount of $214,000. And again, it shows the potential payments, and there's a graph of the payment history for quite a few years. Any questions? All right.
Commissioner Arriaga.
Yes, sir.
Well, back to the budget, and maybe
Sure.
I'm ahead of the game. When do we start preparing the budget for the biennium?
For the biennium, okay, we prepare the budget on a yearly basis. We don't do the biennium any longer because we're not under appropriations. But we'll start looking at it this month in February. Me and Aretha, our budget analyst, she and I will look over the budget. Then we'll start making our recommendations to the executive director.
And the reason for that is, although we're way ahead, a whole year ahead, but coming that legislative session is going to be next year, to look at the Real Estate Recovery Trust Fund and how that's being done and paid out. And perhaps someone wants to carry the flag, a legislator on. I'm still convinced there's some abuse in the system, just don't know how to correct it. So just consider talking about that in the future, Madam Chair.
And of course, when you mean abuse, you believe that there are people that were paying funds out that were not performing licensed activity when they made a claim, or when a claim was made. I just want to be sure that it wasn't internal abuse, because we have a lot of visitors in the room. Okay. Yes.
I will point out that just this last legislative session, we did have some additional changes made to our recovery fund statute and our statute in general that specifically itemizes which activities are not real estate brokerage activities, and also tried to close some of the loopholes in terms of broker entity corporations and designated brokers. So going forward, I think you'll see that some of your concerns are already addressed in the statute.
Thank you.
All right, and my last report is the S4 report. Keep going. Was this it? No, I'm sorry. This is it. This is a report on the Inspection Recovery Fund. And on this one, we have no claims that have been paid in this fiscal year or in the last 3. We do have 3 pending claims for the next 90 days of $33,000. The ending market value of the investments is $548,941. Unobligated cash available is $72,709. The total account balance, less the amounts reserved for future payments, is $588,650. And any amounts in excess of $600,000 at the end of the year as of December 31st have to be paid back to the General Revenue Fund, and this year we submitted $21,650. Any questions?
Are there any questions? Thank you, Ms. Huerta. Thank you, all of you staff people, for your reports. We appreciate your hard work. Agenda item 7 would be a report from the Executive Committee, which met this morning and looked at several things. One was the advertising rule, which is agenda item 16. I believe you know that we've had a working group that worked on the advertising rule, and then the Executive Committee sort of took that work and massaged it a little bit, and that was posted in your materials as agenda item 16. The goal that we gave that committee to look at in altering our advertising rule was really 2 broad subjects. One, create an advertising rule that is fairly simple and easy for a licensee to understand how they could be in compliance with advertising rule. And second, to make it very easily understood who the person in charge is, who the broker is, so that the consumer who is concerned can find the person in charge. The Executive Committee, when we get to agenda item 16, is likely going to recommend, and I'll just go ahead and tell you so you can be thinking about it between now and 16, or item 16, that we not post this officially yet. We publish it on our website for people to make comments on it as we begin the listening tour on strategic planning, which will take place in March, so that we can get more stakeholder input. And assuming that we get that, then maybe change the rule a little bit based on those comments from the listening tour and post it in perhaps May, for perhaps final action in August. So that's what we're going to recommend to you when we get over to item 16. We also created a hand open carry, if you will, policy that we will look at in agenda item 22, which has been handed out to you to the commissioners at this meeting. Our staff worked very closely with the governor's staff to create a policy that was fair and acceptable to the governor's office, and that's what we'll be presenting in item 22. We also considered going ahead and sort of codifying the process that we use when we elect officers, and to do what we did at this time, which was to say at our November meeting that if anybody, that we'd have the officer positions coming up in the February meeting. If anybody was interested, they could let General Counsel or the chairman know that they were interested. These roles that we elect are not political roles, so it's not something that you would go and lobby the other commissioners to be the vice chairman or the secretary of the commission. So that we're just going to put all that kind of in a policy and have it available so that everybody knows how it works. And there's everything, in continuing to be as transparent as possible. We also talked just a little about future agenda items and some of the things that we had heard, both mythical and real, at the TAR meeting. And for those of you who were at the TAR meeting, you can probably think about the mythical things that people made up that we were going to do today. Fun stuff. So now we would, unless you have any questions about the executive committee's little meeting this morning. Okay, good. Then we will look at agenda item 8, and I believe Chairman of the Education Standards Advisory Commission, Susan Jones, is here to make a report on that committee's behalf.
Good morning, Commissioners. I'm privileged to be here. I wanted to give you a report on the Education Standards Advisory Committee meeting that was held on January the 8th. During the meeting, the committee voted unanimously to re-elect myself as the chairman of that committee, and I'm very honored by that trust and by the ability to serve, and Rick Albers as our vice chair for the coming year. It's such a great honor to have this position with my passion for education, which has been lifelong, and so I'm looking forward to serving as chair for another busy year that we're going to have. At the meeting, the committee reviewed a proposed rule that specified the requirements for instructors of adult education training courses. The committee had a great discussion and heard from several members of the public that were there, including university professors and instructors from different schools. And so we got a lot of good input on all of this. We believe that adult education instructors need a little bit different perspective on how they reach out to their students than what maybe other classroom, if they've had classroom experience before, might have given them. So we have a recommendation before this body, and we do recommend that this rule be proposed for publication and public comment at today's meeting. The rest of the day, most all of the day, was taken up extensively reviewing the 30-hour pre-qualifying property management course, and that kind of reflects back to the concerns that some of you spoke of earlier about the broad number of complaints in the property management field. We would like to certainly get more input on this. We saw many glaring things that were not in the textbooks previously, and maybe some things that don't need to be in there. We do have to remember that this is a survey course. It's not a drill down course. So I remember when I was in college, there were always courses you took that they always called them the weed out classes. And maybe that's what this needs to be, in a sense that it shows students as they're going into the profession that this is not easy, this is real, and this is hard, and it has a lot of rules and regulations. And so we want to make sure that all of those are in there. So we did get that proposed, and we have asked the staff to compile our recommendations into a rule and course guideline form that is before you today to be proposed. At our next meeting, the committee will review real estate marketing, course, the qualifying course. We'll be meeting on April the 18th in Austin. I thank you for your time, and do you have any questions?
Are there any questions? Congratulations on your re-election, I think.
Thank you.
Thank you, Ms. Jones. And Chairman of the Inspector Committee, Mr. Reinhardt's not here, and I believe Tony Slagle's going to make the report for that committee.
Good morning, Commissioners. I'm Tony Slagle, Government Affairs. I'm also the staff liaison for the Inspector Committee. Yes, Mr. Reinhardt unfortunately couldn't make it this morning, so he asked that I provide a very brief summary of the meeting. The Inspector Committee met on Monday, February 1st. The main focus of the meeting was the election of officers, and the committee re-elected for the upcoming year Stephen Reinhardt as chair, Lee Warren as vice chair, and Diana Rose as the secretary. The only other agenda item up for consideration by the committee were comments regarding the proposed amendments to 22 TAC 535-210 fees, which is on the agenda today for your approval. It's item 15. At the time of the meeting, there were no comments, and the committee took no further action regarding the rule other than to continue this to support its approval. There are a few things moving forward the committee is going to be looking into at their ongoing SOP update. The main focus this upcoming year is likely to be education issues, hours, more scrutiny in terms of the courses moving forward, and they will also be looking at an issue regarding static testing moving forward as well. The committee, that's really what the focus of that meeting was. A very brief meeting. The committee is scheduled to meet again on Monday, May 2nd at 9 a.m. And if I may take this opportunity just to mention that there is currently a public member vacancy on the committee. Brian Wood's term expired on February 1st. He has stated he's not interested in continuing. He's willing to serve until replaced, but if there's anyone who knows of anyone who's qualified or interested in being a public member, if they would send in applications, we would love to review them.
Any questions for Mr. Slagle? Thank you for your time. Thank you for your report. Okay, we have agenda item 10, which is an opportunity for people to speak on non-agenda items, and I have two people wishing to speak on a non-agenda item. Christy Dunn, are you here? You want to speak? And 3 minutes. From when you start, not from when I call you up here.
I'm a little bit sick, so I apologize if I sound a little raspy. Good morning, Commissioners. My name is Christy Dunn, and I come before the Commission today with gratitude for allowing me to speak. I am here today seeking the approval of the 330 hours of coursework that I was denied as a student in a home inspection course. For 20 years, I was a high school English teacher, serving in the capacity as an educator of advanced placement English at the senior high school level. I certainly feel I know the meaning of hard work and dedication. Well, in June of last year, I walked away from that career to take on an even greater challenge, obtaining licensure as a professional home inspector and a small business owner in Texas. On December 31st, 2015, I feel that dream was dashed. When I enrolled in my school as a student in the summer 2014, I was not given a time frame with which to work because no time frame existed. I dutifully pushed along, managing a full-time, high-level teaching position while continuing my intense studies of the home inspection industry. As you might imagine, teaching English and inspecting homes are truly separate entities. This past November, I was informed that my courses would expire the following month. In a near panic, I completed all of the required bookwork, quizzes, activities, you name it, I got it all completed. Unfortunately, with multiple holidays in the months of November and December, along with simply not enough time, I was unable to complete the 2.5-hour proctored exam, have it scored, receive the certificates from Texas State University, all before the expiration date. I did everything I was asked to do based on the information I was given when all of this started, which was no timeline for completion. As an educator in Texas for 20 years, I know what a good educational process should look like. At the high school where I taught, incoming freshmen fell into the state of Texas's new 4-year plan requirement. it had changed from the previous plans, which is why the currently enrolled 10th, 11th, and 12th graders stayed the course on their respective plans. This type of transition makes sense, and it works. Now that I'm a student, I feel I'm struggling to understand how a course I started and completed is suddenly no longer valid. I do believe changes in regulation are important, and they are necessary. I understand that wholeheartedly. If, though, they positively are going to impact current and potential inspectors. But the situation with a stagnation in the reapproval process of the courses is kind of like telling all those 10th, 11th, and 12th graders, hey, your graduation is on hold until further notice. Okay, I'm in a position of that senior, that 12th grader, who's met all the requirements under the original guidelines, yet is not able to graduate and receive a diploma. I am here seeking approval of all my coursework. I have all my certificates. And that I be allowed to register to take my state exam. I'm very eager to sit for this exam and move forward. The only item, this is the only item I have left in this entire process. On a side note, I just wanted y'all to know that I received very high marks on my coursework and my proctored tests. I would be a tremendous asset to the state as a licensed professional inspector. I think one of a few women in the field, and a small business owner. That's my biggest goal. I did my job. I worked very hard to fulfill every requirement. I just wanted the commission to see who these decisions and who these rules may be impacting. Thank you for your time.
Thank you.
Mr. Chairman.
Just a moment. We have a question.
Yes, sir.
I'm just wondering, have you spoken to anyone at the agency prior to today?
Yes.
Okay.
Yes.
And
from the Real Estate Commission, is that what you're asking?
Yes,
Yes,
ma'am.
I did call, actually before the December deadline. I called in to ask because my school informed me that these changes were coming, and that's when I went into a panic. So I did contact the number, and I know they talked about the whole time. I don't remember. I didn't wait very long. I don't know if that was part of her presentation. The lady that I spoke with told me that as far as she knew, there weren't going to be any real changes, so I thought, okay, I'm good to go. So I proceeded. I did contact two of the commissioners on this board, or on this commission. I did speak my mind. As you can imagine, this has set us back. I quit my teaching job. We're living on one income. I'm not here to tell you my sob story. I'm just ready to open my business. I'm just ready to do this and be a good inspector. I did contact, Kimberly is the lady that contacted me. She received all of my certificates. She told me I could send them all email, so I did that. I completed the affidavit. She sent me an email on Thursday saying that only 120 of those total hours for professional licensure were the ones that were accepted, because I believe that expiration date is coming up March 1st, and I had met that expiration date. So I was taken aback. I'm not sure exactly where things stand. I went on the website to look for updated stuff. That particular part of the inspector website for TREC is not working. It gives you a little sad face with a thermometer. And I went on just now just to see, and from my mobile device, I still couldn't get anything. And I understand if it is changes that are being made. My school has not been issued their reapproval, which they said started off as a renewal. Renewal and reapproval to me are two very, very different terms that have very different consequences that come with those. They have not been reapproved. So right now, I am literally waiting. I don't even know what I can do, when I can begin, either to get my hours that I already received, and I don't have to go back and do anything. I just need to take the state test. I mean, that is all I've got left.
Who'd you speak to? Which commission members? Do you remember?
Yes, Commissioner Martinez and Commissioner Leonard.
Okay.
Yes,
What's the name of your school?
The home inspection school, a better school for building. Better School for Building Inspection. Say the whole name.
Okay, so Commissioner Martinez.
Sure. I just want to say, first off, thank you for Ms. Dunn and Mr. Dunn for joining us here today. And again, while running statewide, been checking my emails and things like that. And as anyone can attest, my personal phone number has been on the TREC Commission website since I've got on the commission 4 years ago. So Don't all you realtors start calling me in the middle of the night. Text me after 10, call me before. But I want to say thank you for going through and showing professionalism through that. And I know that your husband's done a great job serving as mayor of Cibolo and dealing with these issues. What I had done, commissioners, just so you know, I received the information, I asked for clarification, sort of an executive summary of the situation, and then I sent that on to staff to have them review it to figure out, as is the case in many cases, what sort of data we have on it, historical or otherwise, to give us some guidance. So I communicated to Mrs. Dunn that I was hoping to have an answer for her after today's meeting and visiting with staff in between our recesses. But that's where I'm at in the situation. So again, thank you for joining us today. I didn't know y'all were going to be here, but again, glad you're here.
Surprise.
You
did. I don't know now if you still need to call me after. You did say you were committed to calling me after the meeting, so I don't know. Depends on if we're still available.
I'll call you just so I can.
Did anyone else have any questions for Ms. Dunn? Okay.
So if I may, Carrie Lewis, General Counsel, first of all, especially for our new commission members, this is a public comments on non-agenda items. There is no action that the commission can take at this time, even though you're requesting them to take action.
Yes, ma'am, I understand.
They legally cannot do that. And then I would just like to make a couple of factual corrections regarding what your provider may or may not have told you. This was not a change in the rule. Certain courses that didn't used to have an expiration date over 4 years ago were given an expiration date of December 31st, by which time they had to reapply. And providers knew about this for years. It's a provider's responsibility to notify their students if a course is going to be expiring. I would say 30 days is not adequate time. And it is not a renewal of a course. It is a reapproval, and that has been not a change. Again, that has been in our rules for a long time. So you may have been given some misinformation by your provider, and you may actually have a complaint against your provider. I would suggest maybe at our break, meet with our Director of Education, and so she can find out a little bit more specifics about your situation and what we can and cannot do. But it is a violation for a provider to issue a certificate of completion after their course has expired. So there are also certain things that our education department looks at when we approve a provider, and that is, how are they going to refund somebody if they didn't meet their requirements and obligations to the students. So perhaps you can look at that as well.
May I ask you a question just to make sure I understand? What I'm hearing you say is that this was the school's providers have known about these expiration dates?
Yes.
Okay.
For 4 years.
For 4 years?
Yes.
Okay.
It's been in our rules for 4 years.
And the word renewal versus reapproval in that 4 years also?
We call it subsequent approval.
Okay, which is?
Which is you have to apply for a complete approval of the course to meet the current standards that are in place at the time of your application.
Okay. All right. Well, thank you. I appreciate it.
The lady in the blue jacket is the person you want to see on the break.
Yes.
Okay?
Thank you, ma'am. Thank you. Thank you, commissioners.
Thank you.
Thank you. Alan Dunn also. Mr. Dunn, hello?
I think at this point, everything I was going to speak on seems better.
Okay. Thank you. Awesome. Are there any other general comments from visitors on a non-agenda item and you failed to fill out a white piece of paper? Okay, so at this time, the commission will go into an executive session to discuss pending litigation or obtain advice of legal counsel on agenda items pursuant to Texas Government Code 551.071. The time is 11:20. We will be out for 45 minutes. This 45 minutes does not count for CE credit. So if you want to go have lunch and come back.
Madam Chair.
Yes.
I would like to just take a moment to recognize our former General Counsel, Ms. Loretta DeHay. If you please stand up.
Okay. Yay. Thank you, Commissioner Martinez. And I think we all forgot to say thanks, everybody, for coming. It's kind of fun to see all you here. So we're going to go into executive session. We call the meeting back to order at 12:16, and I will hand the gavel to Commissioner Turner for agenda items 12 and 13.
Thank you, Madam Chair. Agenda item 12 is consideration and possible action regarding proposal for decision in the matter of TREC versus Danetta Renee Williams. Do we have a staff member that's going to?
Good morning, Carrie Lewis, General Counsel. This is a proposal for decision that was issued in this matter by ALJ Howard Seitzman, and the recommendation was that a reprimand should be issued against Ms. Williams' license and a $1,000 administrative penalty should be assessed against Ms. Williams, and that the Ms. Williams' real estate broker's license should be suspended unless and until she pays the $604.50 license renewal fee and the $30 dishonored check processing fee and a $1,000 administrative penalty fee. And Mark, if you'll tell what staff.
Mark Moore, Standards and Enforcement Services. We agree with the proposal for decision and recommend its adoption. The lawyer on the case, Sharon Harris, is available for questions. Ms. Williams appeared telephonically. I'm not sure if she's present or not.
Ms. Williams, are you here, or is anyone here on behalf of Ms. Williams today? Okay.
Are there any questions?
No, I'll note for the record that on page 7 of the proposal for decision, in the administrative law judge's dicta, they note a $402.50 license renewal fee. The conclusions of law, which is what we're adopting, that's a typo. I'm just stating that for the record. We're adopting or going to vote whether or not to adopt the fee that's included in the conclusions of law on page 9 of the decision, which was the $604.50 in addition to the other penalties. So at this time, I think I can just call the question. All those in favor of accepting the recommendations of the SOA judge and adopting this proposal for decision, please say aye.
Aye.
Aye. Any opposed? Okay. Moving on to agenda item 13.
Agenda item 13 is a motion for a hearing in the matter of Erasmo Garcia. As you may recall, at your last meeting, this commission gave a final order in this case, which had been before SOA, ordering that Erasmo Garcia be assessed an administrative penalty of $24,000 and that the real estate salesperson's license of Mr. Garcia be revoked. Mr. Garcia did file a motion for a hearing, which is in your material, and staff attorney Beverly Ravenberg filed a response to that motion for a hearing, and that is before you today. I believe both parties are here to give testimony.
I believe we have Oscar Cantu, is the attorney for Mr. Garcia. Mr. Cantu, we'll give you 5 minutes, okay?
Thank you.
Yes, sir.
Good afternoon to the commission. I know we all share being here in Austin, suffering through the wretched winter weather of Texas together. I get any chance I can to come indoors at this horrible time of year. Commissioners, what we have initially is an objection to this particular order under the Texas Occupations Code 1101 because it was never served upon Mr. Garcia. If you look at all of the filings in this particular case, every one of the documents has a certificate of service giving both the email and the certified mailing address of all the recipients who are entitled to notice and service of those documents. In this particular case, despite the fact that it's about a man's license and the revocation thereof, this particular order and determination was not served upon Mr. Garcia. It was merely sent to me. Now, while this is usually prudent and proper for an attorney to get a copy, the Occupations Code, Section 706, specifically requires that the license holder be served with a copy of the order of revocation to have a chance as long as a notice of his possible appellate rights. What happened in this case was it then fell upon me to make sure that he got a copy, and I mailed it to him. He did not receive it, and so his deadline to respond timely was lost. When he pointed this out to the administrative law judge And to the TREC attorney, they both properly noted, well, we're sorry, our hands are tied. There is no power anymore for us to do anything about it. So the only proper vehicle for him to do to point out this objection as to not being served properly with the order and a notice of his rights was to file a motion for new trial. That was the objection in principle part number 1. Number 2 is a rather lengthy list of arguments which he would forward had he been given a proper timely notice to appeal the particular decisions. There are 42 different sections. They're very specific as to factual determinations and objections that he has, yet it's very simple. If we simply affirm the fact that his license is to be revoked without notice directly upon him, then none of his arguments will be heard in this case, and the appeal has to move to the next level. I, for one, take great lengths to avoid formal procedures and process. I try to get everything done at the agency level, because who knows better about real estate than TREC? Who knows better about dealing with governmental violations than SOA? And so we prefer that these types of problems be handled here in Austin in the form of administrative hearings. So it's a very simple motion, basically one of form, that he was not given proper notice. And as far as evidentiary proof, you merely need to look at all the documents in the file. Ms. Rappenberg is very thorough. This hearing was noticed 4 times upon me and Mr. Garcia. The rescheduling of this particular hearing was noticed twice upon me and twice upon Mr. Garcia. Yet none of that evidence appears upon the determination of the administrative law judge's order or his notice of his rights of appeal. His name does not appear anywhere as having been given notice. So I know attorneys are often accused of being a little bit long and wordy. When it's that simple, I like to lay that before the commission and take any questions over a very brief argument.
Commissioners, anyone have any questions for Mr. Cantu?
Mr. Cantu, is my recollection incorrect that Mr. Garcia was present during that November meeting in this building, in this very room?
He may have been, but I was not. But the actual, what I'm talking about is the order as it comes from the judge. The initial proposed order with his deadlines to object was never sent to him. Notices of the meetings have been sent multiple times to him and to me. Everything else was sent to both of us except the important document, which is the judge's determination, proposed findings of fact, and conclusions of law.
So it was the PFD that you're saying was not, the proposal for decision from the SOA judge that you're saying was not properly served on your client?
Yes, sir.
Not the order from TREC adopting that decision?
Correct.
Are you saying that somehow prevented you from appearing at the last meeting, or?
No, sir. I was in trial at the last meeting, and I had requested a reset and filed a continuance, or filed a request.
Okay.
Counselor?
Yes, sir.
Counselor, how long have been the attorney for the realtor you're representing?
Approximately 2 months before the administrative law hearing, since that time.
And in years, days, months?
Approximately 6 months.
You've been attorney for only 6 months?
No, for him. I represented him in this particular case for about 6 months.
And that's it?
Yes, sir.
Nothing before that?
No, sir. I took over approximately 2 months before the administrative law hearing in front of SOA was set, and picked up the file at that time, filed a few documents, and had excellent communications with Ms. Rappenberg and with the commission, had no problems whatsoever electronically filing my documents, and the entire process was very smooth and without a hitch.
Did you have an attorney before you?
There were 2 attorneys before me, Mr. Matt Coert and an additional gentleman whose name I don't recall.
Thank you.
You have a question, Mr. Westcott?
Yeah. So explain to me how the SOA's administrative rule is wrong, where it was my understanding if you're represented by an attorney, then service would be valid if you're either served personally or your attorney is served. Why is that wrong in this case?
Well, in the particular document we're talking about, the document coming from the administrative law judge, Occupation Code 704 requires that the individual or the licensee be served. So you don't want to create a situation or a potential conflict where I am now an agent of the state and I am responsible for making sure that he gets served with notice of a pending revocation, whereas it's actually TREC and SOA that wishes to complete this process and do it. So I become an agent for the state rather than having the state serve him directly.
But isn't it the case that under SOA's rules, it's acceptable to serve either the attorney or the respondent?
For notices of hearings and things like that, but what's important in this particular case is just going straight to the code itself. It says that that person has to be served, not the attorney or the party representing that person. And then when we change to section 701 of 1101, we look at the definitions for the person, the license holder. Those are all individuals and speak directly of him.
Mr. Martinez?
Yeah, I appreciate the explanation you've given here today. I'd like to hear from counsel on our side to some of the process that we're discussing.
Thank you.
Any other questions for Mr. Cantu at this time? If we have any more questions, we can call you back up, okay? So if we can hear from the staff attorney on the case now, please.
Mr. Presiding Member, Commission members, I'm Beverly Rabenberg. I'm here on behalf of TREC Standards and Enforcement Services Division. Our written opposition, which answers some of Mr. Cantu's questions, starts on page 145 in your materials. You have to remember that we're here on a motion for rehearing. We're not here to review the SOA Administrative Law Judge's proposal for decision and enter a final order. You already did that at your November meeting, as we've already talked about. Under Commission Rule 533.8, a motion for rehearing, the license holder has to set forth a particular finding of fact, conclusion of law, ruling, or other action which the complaining party asserts caused substantial injustice and was error. While Mr. Garcia's raised pages and pages of problems in his motion for rehearing, those issues should have been raised long before this, and I'll get to why here in a minute. He had the chance to file exceptions before the State Office of Administrative Hearings. We're unable to see how those arguments, the myriad pages he gave us, involve substantial injustice and that were error, and those reasons alone the motion for rehearing should be overruled. But there are other reasons to deny, and now I'm going to get to the crux of the matter. Please go with me to page 149 in your meeting materials. Frankly, I have to go to 144. I can read that page number and flip ahead 5 pages. Starting here is the Commission's history of disciplinary proceedings with Mr. Garcia. It started back with a hearing in 2009. This is the 4th proceeding we've had. He's been before the State Office of Administrative Hearings. He's had counsel before. We've had case 1, case 2, case 3, and this is the 4th case there on the top of the next page. He's well aware of procedure. He knows when a PFD is issued that there's a certain period of time to file exceptions. His attorneys have done it in the past. He was fully well aware of what was supposed to happen and when. We very carefully looked at the SOA rule after the argument about service was raised, and SOA's own rules, as we point out in our response, states that it will be served on the respondent's attorney. We have to remember this is the SOA Administrative Law Judge's PFD. It's not a final proceeding before the Commission. It's simply a proposal that they need to respond to. They need to respond to it timely. SOA's rules and the APA require 15 days, actually, and add 3 for mail. So their response was due 18 days after that PFD was issued on October 1st. So something that shows up later. The other thing SOA's rules, specifically, SOA rule has a rule for when you can ask for an extension for that. And they say you have to do it within 5 days before the deadline. So SOA has rules. Attorneys are expected to know those rules or look up those rules. And every hearing notice talks about the SOA rules that are going to be in play. So notice of the proposal for decision that was issued by the judge. Everybody, the law says those have to be 60 days. So you take your hearing date, which is the 5th of August, and add 60 days. You should be looking for it. We're always looking for it about 60 days. From then you start a new clock counting for the proposal for decision to file exceptions. So whether or not they got a copy of it, they should have been looking for it and asking questions. You can even go onto the SOA website. It's online. If you have the proceeding number, you can look it up right now. So he wasn't served and all of that. That is not going to be a valid reason to grant a motion for rehearing at this point. They both knew or should have known what the deadlines were. As for the continuance Mr. Cantu referred to, that was a continuance for an argument before the commission because he was in trial. However, he filed it at SOA. He didn't file it with the commission. The notice was the commission was going to consider the PFD at its November meeting. He didn't file anything with the commission. He filed it at SOA. SOA judge looked at him. I think her thing is dated the 29th of October, and she said, not me. It's, your time for filing exceptions with me is finished. So at that point, he knew something was going to need to happen at the commission. Nothing was filed with the commission. So all of the reasons and explanations and excuses for granting a motion for rehearing that we see that are procedural, every one of those we believe should be overruled because we believe we met the procedure required under both the APA and the commission's rules in terms of what they were told, when they were told, and we believe the motion for rehearing should be overruled.
I would like to clarify one point for the commission too. I just looked up that statute 1101.706. That says that the administrator shall give notice of the commission's order to the person. So what we're talking about, or I believe Mr. Cantu was talking about, was the proposal for decision with SOA. That was not the commission's order. So I don't think this section has to do with proposal decision. It's a November hearing, and as he pointed out, that was served on everybody. So we did comply with that statute.
Any commissioners have any more questions for our staff or for Mr. Cantu at this time? In that case, at this time I'll call a question. All those in favor of granting Mr. Garcia's motion for rehearing, say aye. All those opposed, in favor of denying the motion for rehearing, say nay.
Nay.
Nay. Okay, motion for rehearing is denied, and I will pass the gavel back over to our chairperson.
Thank you. Thank you, Commissioner Turner. We will look now at the agenda item 14, recovery fund cases. Thank you, Ms. Worman.
Madam Chair and Commissioners, the first item under agenda item 14 is recovery fund case number 15-025, Green Ridge Townhome Association versus Niaz Nick Faruqi.
Commissioner Arriaga, did you have a motion?
Yes, Madam Chair. In item 15-025, I move that we authorize the payment of $100,000 to the plaintiff.
Have a motion. Do I have a second?
Second.
All in favor say aye.
Aye.
Opposed, no. Motion carries. Ms. Worman?
Yes, Madam Chair and Commissioners. Next is recovery fund case number 16-001, Ed Underwood versus TX PMB LLC, Beon LLC et al.
Mr. Westcott?
Yes, Madam Chairman, I'd like to make a motion. In case 16-001, I move that staff is authorized to make payment of actual damages, attorney's fees, court costs, and interest is awarded in the judgment, plus reasonable attorney's fees for post-judgment filing of recovery fund application.
I have a motion. Do I have a second?
Second.
All in favor say aye.
Aye.
Opposed, no. Motion carries. Are you on this next one?
Yes, Madam Chair. The next item is recovery fund case number 16-003, Ruth Alvarenga and Andres Alvarenga versus Prosperity and Associates Incorporated, Virginia Trevino and Robert Reyes.
Mr. Alley? A motion. Do I have a second?
Second.
All in favor say aye.
Aye.
And opposed, no. Motion carries. Ms. Worman?
The next item is Recovery Fund Case 16-004, Angela and Brian Hapgood versus Eric Lee et al.
Commissioner Martinez?
Yes, in this particular case, I'd like to authorize payment of actual damages, attorney's fees, court costs, and interest as awarded in the judgment, plus reasonable attorney's fees for post-judgment filing of recovery fund application.
Was case 16-004. Do I have a second? Have a motion, I have a second. All in favor say aye.
Aye.
Opposed, no. Motion carries. Last but not least.
Last but not least, Madam Chair and Commissioners, is Recovery Fund Case Number 16-005, Damian Bird versus Robert Edwards.
Mr. Martinez again.
Yes, in this particular case, I'd like to authorize payment of actual damages, attorney's fees, court costs, and interest as awarded in the judgment.
That will be case 16-005. I have a motion. Do I have a second?
Second.
All in favor say aye.
Aye.
And opposed, no. Motion carries. Thank you, Ms. Warman. Agenda item 15, discussion and possible action to adopt amendments to 535-210. We're still on you? Okay.
Yes, Madam Chair and Commissioners. This particular amendment was proposed, and we are recommending adoption of these amendments to align this rule with statutory changes to Chapter 1101 adopted by the 84th Legislature, and rule changes to the education course delivery standards. A charge for providing certified copies of documents was also added. We did not receive any comments on this rule.
No comments on this rule. Commissioner Arriaga, will you make this motion for us on 15? 189. Yes, sir.
Madam Chair, I move that staff is authorized on behalf of the commission to submit for adoption amendments to 22 THC subsection 535.210.
Have a motion. Do I have a second?
Second.
Any discussion by the commission? All in favor say aye.
Aye.
Opposed, no. Motion carries. Agenda item 16. And I do have two people who wish to speak. We will see later if they still want to speak.
Madam Chair, item 16 is discussion and possible action to propose a new and repeal current 535-154 advertising for publication and public comment. I believe this is the rule you were speaking about at the Executive Committee.
Indeed. So you're done presenting. To remind you what the Executive Committee is going to bring forward is to publish the draft rule on our website so that people may become familiar with it and hopefully already be familiar with the existing rule so they can understand the difference, and to use this as part of our listening tour around the state in the strategic planning process, which will be in March, and then perhaps come back with some good input in the May meeting to perhaps propose a rule. And with that in mind, I had two people who wished to speak. One person from the committee that worked on this, the working group that worked on this, Mr. Harpold, and another lady from San Antonio, Michelle Ross. So, Mr. Harpold, you want to talk or you want to wait till we get really in it? No, it will not. We're going to make a motion to publish, but not propose, just so that we can get dialogue going with stakeholders.
Merely to publish, sorry, Madam Chair, but to the TREC website, not in the Texas Register. So not taking that first step in the actual rulemaking procedure, correct,
Right,
Madam
that's
Chair?
correct.
To
That's
put it on the website so that the public can
That's
have
correct.
access
So
to it.
I believe what we end up with in May will be different than what we have today. So I'm happy to hear 3 minutes of your eloquent speaking, if you feel the need. It's up to you. Oh, wait.
We don't know what you're going to say.
I mean, you can say something, but it may not be true. Okay, turning the timer on. Let me start counting before you get here.
And then who's following him?
The lady from San Antonio, is she still here? Hold on. Is Miss Ross still here from San Antonio? Checked out on, okay.
Can I proceed?
You may.
Thank you. So,
I didn't really mean that. Sorry.
I thank you for letting me speak. I did serve on the committee. A little bit about myself. I'm a lawyer from Houston. I've been representing real estate brokers, licensees, agents, probably the last 25 years. I don't know anybody in Texas has dealt more with claims or adversarial situations involving agents and brokers, licensees across the state of Texas, and dealing with whether it be a lawsuit, a trial, administrative hearing, a question, a demand letter, anything related to the conduct of a licensee. I've pretty well dealt with the last 25 years and still continue to deal with. And with that background, I guess the bottom line on what's being proposed, specifically with respect to advertising, the definition and the application of that definition seems a little broad and not really a real practical need for it. And specifically, it's up there on the board. You can see that advertising, at least has defined here, encompasses any form of communication, any form. And I'm seeing this really for the first time. I tried to look at it on Sunday and I didn't get a chance to see it. I couldn't pull it up. But anyway, it says any form of communication to attract public attention. And that definition doesn't really seem to serve what truly would be advertising by a broker or a licensee. And I guess, you know, in specifically going to my objections to some of the things in here is taking that advertisement and that issue and requiring that a broker or licensee put on their advertisements licensed by the Texas Real Estate Commission, which has never before been a requirement of any licensee to put that in an advertisement or to put that on a yard sign. And I think that's really the real issue, is something to think about as we go around the state discussing this, is having the licensee be burdened with doing things, regulatory things, unnecessary things, just for the sake of doing them. And that's my objection to some of what, and I don't know that I can cover it all in 3 minutes, but just to boil it down for you, specifically requiring a licensee to put on their yard sign, licensed by the Texas Real Estate Commission, which never before has been a rule or something that is a requirement of a licensee. And to be honest with you, I don't see any authority in the License Act to require that. And I'm not sure, I can't figure out how that promotes or helps the consumer knowing that. In today's world, the consumer is pretty sophisticated as far as its ability, am I done? Its ability to require or obtain information about a broker, licensee, or the world in general. And so it seems as if what is being proposed goes way beyond what is necessary to protect the interests of the consumer, and it's things that have never been proposed before.
I have a question.
Thanks, Grant. Oh, wait, got a question.
Just
How about
one observation.
Yes or no question?
Pardon me?
Nothing, go ahead.
Thanks for your time today, and appreciate you for boiling it down. Do you think, in your professional opinion, do you think stating where realtors receive their licensing from would increase the number of recovery fund cases that we would receive?
No.
Okay, thank you.
Thank you. Somebody else have a question? You make a motion. Commissioner Jones, did you have a motion for us?
Madam Chair, I'd move that I'd move that the staff is authorized on behalf on this commission to publish the proposed draft rule on the TREC website and for comments and as a topic for the strategic planning listening tour in the month of March 2016.
I have a motion. Do I have a second?
Second.
All in favor say aye.
Aye.
No opposed, no. Motion carries. Thank you. Agenda item 17.
Agenda item 17 is discussion and possible action to propose amendments to section 535.63, approval of instructors of qualifying courses. The amendments are proposed to clarify qualifications needed to become an approved instructor of a TREC-approved adult instructor training course. This amendment was recommended by the Commission's Education Standards Advisory Committee.
Okay. Commissioner Westcott, motion?
Yes, Madam Chairman. I'd like to move that staff is authorized on behalf of this commission to submit the proposed amendments to 22 TAC Section 535.64, content requirements for qualifying real estate courses in the form adopted by reference, as presented along with any technical or non-substantive changes required for proposal to the Texas Register for publication and public comment.
A motion to have a second?
I have a point of order.
Oh, was I on the wrong one?
Yes, sir. We're on tab 17.
Sorry. I apologize for that. Off my game here.
The motion is the same except for .63 instead of .64.
There we go, yes. So instead,
That's what
22
you really-
TAC Section 535.63. There we go.
Thank you, all of you, for, takes a village.
It does.
And I have a second. Is there any discussion? All in favor say aye.
Aye.
And opposed, no. Motion carries. Agenda item 18.
This is discussion and possible action to propose amendments to Section 535.64, content requirements for qualifying real estate courses. And this is what Chairman Jones, Susan Jones, spoke to you about earlier, that a lot of effort went into proposing the property management qualifying course requirements and guidelines, and staff recommends that you propose the amendments and guidelines as presented.
Commissioner Leonard.
Yes, I'd like to move that the staff is authorized on behalf of this commission to submit the proposed amendments to 22 TAC 535.64, content requirements for qualifying real estate courses in the form adopted by reference as presented along with any technical or non-substantive changes required for proposal to the Texas Register for publication and public comment.
I have a motion to have a second.
Second.
All in favor say aye.
Aye.
And opposed, no. Motion carries. Agenda item 19.
Discussion and possible action to propose amendments to Section 535.73, approval of elective continuing education courses. And these amendments are simply to correct the language that is currently there so that it is clear that the intention is to limit the daily presentation to 10 hours and not to limit the length of the entire course.
I have Commissioner Stevens.
Madam Chairman, I move that the staff is authorized on behalf of this commission to submit the proposed amendments to 22 TAC 535.73, approval of elective continuing education courses as presented, along with any technical or non-substantive changes required for proposal to the Texas Register for publication and public comment.
I have a motion to have a second.
Second.
All in favor say aye.
Aye.
Opposed, no. Motion carries. Agenda item 20. Ms. Huerta.
Good afternoon. This is the investment policy for the Real Estate Recovery Trust, Real Estate Inspection Fund, and Reserve Funds. This is the same policy that was approved at the February 2015 Commission meeting. There are no changes to this policy. As the policy states, the investments are laddered so that they mature at different times throughout the year. Funds are held and invested with the Texas Treasury Safekeeping Trust Company in authorized investments of state funds per Government Code, Section 404.024 and .106. Section 2256.005 of the Government Code requires that the investment policy be reviewed and approved annually by our governing body. Are there any questions?
Commissioner Arriaga.
Madam Chair, I move that the commission approve the Texas Real Estate Commission investment policy as presented.
I have a motion to have a second.
Second.
All in favor say aye.
Aye.
Opposed, no. Motion carries. Agenda item 21. It's you.
Madam Chair.
Yes, sir.
As part of our biennial strategic planning process, the agency conducts a listening tour with at least 5 locations around the state, north, south, east, west, and central, during the month of March. We have a tentative schedule in place, and we're also looking at adding other locations perhaps 2 additional locations as well, based on demand. We'll be publishing the schedule in a news release, and the topic list is recommended for your approval here today. You've received a draft of the topic list on the dais, and it actually includes, anticipating the action you took in a prior agenda item, it includes the question on how we can make the current advertising rules simpler for license holders and more effective for consumers. Willing to accept any discussion or recommendations with respect to the topic list, and you will be informed and, of course, invited as commissioners to come to any one of the listening tour locations in an area near you.
So, Commissioner Martinez, you want to make a motion here?
I would like to make a motion and approve that the commission approve the proposed topic questions listed for the strategic plan, general survey, and the listening tour as presented, with the caveat that there are a couple of other locations that might be added as deemed necessary.
I have a motion. Do I have a second?
Second.
All in favor, say aye.
Aye.
Any opposed, no. And let me just say to all of the commissioners, I encourage you to attend the listening meetings when they are near you or far from you, if you'd rather travel, and see how the process works and engage yourself in that process. Yes, sir.
Madam Chair, I want to thank Mr. Olmixon for including McAllen on March 23rd. Looking forward to that. Thank you so much.
We're going to McAllen? Okay, agenda item 23.
Discussion and possible action to approve an agency policy on weapons carry. This was handed out to everybody at the dais this morning. This was discussed by the executive committee this morning. And basically, it's a restatement of the current law in Texas following the open carry requirements. Additionally, has a disclaimer on here that says employees who do carry handguns do so in their individual capacity, in no way is required to do so by the agency. You'll note there are 2 motions on your fly sheet. Given that this was changed to just basically be a restatement of the law, no requirement is needed for interpretation, so the second motion is not necessary.
I believe Commissioner Martinez wishes to make this motion. I'll just remind all of the commissioners that this has been vetted through the governor's office.
And I appreciate this opportunity to make this motion and move that the commission approve the agency policy on weapons carry as presented and as approved by the governor's office with full support.
Second.
We have a motion and several seconds. All in favor say aye.
Aye.
And opposed, no. Motion carries. Agenda item 23.
Discussion and possible action to repeal or approve newer changes to TREC forms. We have 4 forms before you today. The first is the reverse mortgage addendum, which we are asking to be repealed. It is no longer needed, since the reverse mortgage loans are now addressed in the new third-party financing addendum, which became effective January 1st. Second form is an agreed judgment review form, and it will be used with our recovery fund program to approve to review a proposed agreed judgment before entry if the agreed judgment may result in an order for payment from the recovery trust account, recovery trust account, and that is due to some statutory changes that went into effect January 1st. The next form is a sales agent sponsorship form, and this form is revised to comply with statutory changes in SB 699, which was adopted by the 84th legislature, and incorporates language which applies to activation of an initial salesperson's license. And as a companion to that, we're asking that sales agent sponsorship form 2 be repealed because it no longer complies with the statutory changes in SB 699. And it previously dealt with first-time activation of newly issued sales agent's license, which now can be done through our RMT tool.
I'm just going to take my time so that we take another period of time so that everybody in the room gets another hour of MC at a CE credit.
So do you have any questions on any of these particular forms?
Does anyone have any
or would you
questions
like a
on any of
little more
these forms that
explanation
they would
on
like
one
to
of the
ask?
forms?
No, but if you give me about 45 minutes, I'll come up with one.
Okay. No, you only need 15 minutes because it's a 50-minute time period that we need to sit here. Right. So,
I think we could move that they finish the rest of this on their own time in the room.
no, I think maybe we'd go ahead and seek a motion on agenda item 23. Anybody? You got it? Commissioner Stevens? Talk slow.
Madam Chairman?
Yes,
I
ma'am.
move that the commission repeal and approve the new or changes to TREC forms as presented.
Second.
We have a motion and a second. All in favor, say aye.
Aye.
And opposed, no. Motion carries. Slowly, I will turn to agenda item 24. Yeah, we ought to talk about future agenda items for about 10 minutes. Or we could look up when is the NAR meeting and see if it conflicts with the next. Do you have something that you want to bring up for a future? Okay, bring something up.
I would just bring up, since this is going to be a future agenda item because it's the advertising rule, is that I would encourage everyone to go to our website and actually read the language. For instance, Mr. Harpold read just a small portion of the definition, but if you read the full definition, you'll see that it has been narrowed and is not so broad. So before anybody makes a snap judgment, please go and read all of the language and come with constructive questions and suggestions to the listening tour, because that's the whole purpose of this process for rulemaking.
Yes, sir.
On the wording of the proposed changes, who came up with the 1/2 rule?
The 1/2 size?
Yes.
We did that several years ago. It's in an advisory letter.
Are other states have similar type rules that you know of?
They're across the board. I would say some other states are stricter than us, saying you can only advertise in the actual name that you are licensed under, and you have to say broker or agent, and that's it. So there's a little more leeway in ours because of the history of the way that I think we have teams and groups and have had DBAs, which is part of the reason for the confusion over the years that has built up. So, yeah.
And the last question, a month or in a week, how many complaints do you have a week? How many complaints do you have from the consumers saying, I cannot find the broker because the sign is confusing me?
They don't typically specify that. They just file the complaint and we have to search for it. That would be the more common thing, but it wouldn't be a complaint that they make like directly, like I can't find the broker.
They don't even know there's a broker to find.
Aha.
There you go. Commissioner Westcott had a question.
Yeah, I just want to bring up the question about the point that the gentleman made regarding the licensed by the Texas Real Estate Commission being on the sign. I mean, what's the argument for doing that? It just seems to me that, like, if you're holding yourself out there as a realtor, you better be licensed by the Texas Real Estate Commission. Otherwise you're in trouble with us.
Well, there's a statutory provision.
Well, let me just, while she's getting that, I want to confuse you a little bit more. Being a realtor is a member of a trade association.
Right.
And being a license holder is something that we do.
Right.
So, yeah, but we have people even today who have said, you're a realtor's license. There is no such thing.
I understand what you're saying, but if you're doing business that would be considered transacting real estate, and as a broker or a salesperson in Texas, then
licensee.
Yeah.
We have a lot of unlicensed activity that appears to be licensed also.
I understand that, but I think
to address a much bigger question is, just because you're a realtor in your case, or a license holder, as the example the chair used, that doesn't necessarily mean you're a responsible, accountable person. We're looking for that person's direct supervisor or broker of record, someone that potentially knows the real answer. Then I'm not happy with the answer I was given.
Right. I guess I don't understand how printing that on a sign, causes one to be the other.
It may not,
You
but
know.
when you look at kind of where the direction was headed as a whole,
Sure.
it is to add clarity amongst all of the names that you could call yourself. You could be the fabulous green skirt team, Chart Westcott team leader, XYZ Realty. Call us. We're fabulous, and we sell lots of property. But how do you know, in all of that, who's the broker? How do you find them? How do you know where to look to see if there is one?
And to get back to your question, there's a statutory provision. It's 652B23 that says it's a violation for one of our license holders to have an advertisement that fails to identify the person causing the advertisement to be published as a licensed broker or agent. So it's the licensed broker or agent where we got to. And if you go through the whole history over time, there's been some leeway given in the interpretation of that by prior counsel and prior commissions that the word realtor, trade association name, counts as identifying it, or the word realty in a broker's name counts. But there's no, there was no specificity, and questions were raised. Well, why doesn't properties? Why doesn't real estate? Why doesn't this? And then you're getting further and further away from the purpose of identifying the person placing the ad as either a broker or an agent.
What's the argument against us just owning those definitions then?
Broker or agent?
Yeah, broker, agent, realtor, realty. I mean,
Well, we can't own realtor.
Why not?
But
it's a trademark.
Oh, that's fine. It's a trademark, but I
But
mean,
we could recognize them, but the discussion group that we were in started naming like 10 or 12, and it's just too hard to know what's in, what's out. And it's one of the difficulties that our license holders have today, knowing what's allowed, what's not allowed. So I think the two options that should be considered going forward is going strictly with the statute, and either you put broker or agent next to your name in every advertisement, or if we want to give it a little more of a gloss over, if you will, or a little more leeway so you can have your names how you want them on your sign for how they look, just at the bottom put licensed by the Texas Real Estate Commission. That's another option. The additional advantage of putting licensed by the Texas Real Estate Commission is that consumers will know who regulates the brokers and the agents.
Just one additional comment that might help. If you're riding down the highway and you see a sign on a field and it says Temple Properties, is it a broker or principal? It's for sale, right? And we don't know, and so when you're making that call, you don't know if you're talking to an agent or if you're talking to a principal. And so that was one of the areas of clarification, because most people understand that there are a lot of professionals in the real estate business, but the distinction between are you acting as an agent for someone else or are you acting as a principal in this transaction makes a difference on what I should tell you, what secrets I should reveal to you about what all of those. It really puts people at a disadvantage, that confusion.
That took 6 minutes. Okay.
Madam Chair, this is reminiscent in a good way of the only meeting on this topic that I sat in on, and I think it's indicative of why we are putting this rule on our website as opposed to placing it in the Texas Register, and why we're going to take it around. And with that in mind, I would like to encourage and maybe even plead with all of you who are here for MCE credit. Look this over, tell your friends, tell your colleagues that these changes are afoot and that we're having trouble deciding exactly what we want this rule to say. And in particular for public members like me who are not licensed real estate agents and maybe don't appreciate the impact, the more public or licensee input that we have on these types of changes, the better, in my opinion. So if you have an opinion, share it with us, and please encourage your other colleagues in the profession to do so as well. come to those listening meetings, participate in the process, because we need help sometimes.
Yep. Commissioner Leonard?
Just a quick logistical question. How soon would we anticipate this would be on our website for public comment?
We can put it up on our website. I would say tomorrow it can be up on our website.
But I guarantee we'll all be asked.
Yeah.
Okay, thank you.
I always say soon.
I would say before we got here today.
Well, I didn't say today. I said tomorrow.
Well, one other thing to be aware of, and I'll take the opportunity to promote it, is the list of questions that you've approved today will actually be on our website as a survey that anyone can take. You don't have to wait for the listening tour location to come and make your comments. And at the listening tour locations, there rarely is time to hear everyone say everything that they want to say, right? So we encourage folks to actually go on our website and answer the survey. You can take there's not limitations on the amount of space that you can comment on each of the questions, and so we do encourage that input. We want it, and the advertising, the resource, this draft for discussion of advertising rules will be up there as well, and then there'll be a big block where you can put all your comments under that particular question on the survey.
Awesome. I believe, are you trying to say something else, Mr. Harpole?
3 minutes are up.
Well, this is actually, we're talking about
Future
future,
agenda
unless you want to
items,
reopen 16.
I don't, because we're going to call the question where we're going to mention that the next regularly scheduled meeting of this body is on May the 16th, and make sure that that works for most of you. The NAR meetings end on the 14th this year.
I'm sure.
Yes, sir. Okay.
If you move it to May 2nd, would that be a problem?
I have no idea. Is that some kind of holiday?
No, that's 2 weeks before, because I guess we return on that Saturday. They have to turn around and come back on, some of us, on Sunday night to be here for Monday.
Commission staff?
I have a personal conflict with May 16th, so if we are considering moving it, I would join in asking to do that. It wouldn't necessarily prevent me from being here, but I would prefer to be able to do what I was intending to do on that day.
I believe commission staff has to check on the availability of this room and other things. Staff in general does not seem to have a conflict. I guess they have to check on the availability of this room.
If you could, please.
We'll certainly check on the availability of the room and
us know.
and then let you know if that's a possibility.
Is everyone else okay with moving it to the 2nd if in fact the room is available? Okay. Then our sort of out there possible next meeting on August the 15th. 16th?
15th.
15th. August.
I'm looking at mine. Yeah.
Does that sort of work?
Yes.
May 2nd is what they were looking at. August 15th? Work?
Yes.
Is there any of the other future agenda items or things? We have gone 1 minute over the required time for you guys to get another hour of CE credit. Thank you all for coming. We appreciate you. Thank you all the staff for all your hard work. Thank you, former Commissioner Justice, for being here for the whole meeting. How awesome is that? We are adjourned.